Thank you for joining us today. This is our 14th annual Environmental Law Distinguished Speaker Series. I am Sarah Everhart. I'm a professor of environmental law, and I'm the director of the Environmental Law and Sustainability Center at Widener Law Commonwealth in Harrisburg, Pennsylvania. I want to give a special acknowledgement and thank you to the sponsor of today's series. Our series is being sponsored by McNeese, Wallace & Newark. So thank you to that law firm for their support. Today's speaker is Professor Lisa Fairfax. Lisa is a Presidential Professor and the co-director of the Institute for Law and Economics at the University of Pennsylvania Carey Law School. I want to give Professor Fairfax as much time as possible. If you have questions for her during her presentation, if you could put them in the chat, we will address those questions at the end. And if everybody could stay muted during the presentation, that would be great. Just help our sound quality. So with that, I will pass it over to Professor Fairfax.
Thank you so much, Sarah. I am just delighted to be here sharing this conversation with everyone. We know that a lot is going on around ESG. And the title of my talk is What We Know, What We Think, and What Comes Next. And my specialty is in and around corporate governance issues. And of course, my conversation today is about how those issues link with ESG. So I will start with what we know, and then I'll talk about what we think we know, and then I'll do a little bit of crystal balling about what I think comes next. So what do we know? We know with absolute certainty that ESG is under intense fire, right? And several trends kind of underscore the fact that ESG is under intense fire. At the federal level, we have several Supreme Court cases making it more difficult to address ESG-linked issues, whether or not that's with regard to diversity or environmental regulation, and really also potential attacks on the Consumer Financial Protection Bureau. We know there's a rollback of the Department of Labor rule, reversing the reversal of the rule as it relates to focusing on ESG and non-pecuniary issues with regard to investment. We know that everybody agrees that the SEC climate's rule, to the extent it's ever enacted, will be challenged in federal court. And we know that Congress seems really motivated around this issue, and that they have working groups specifically focused on a comprehensive approach around negating all of the actions that relate to ESG. And some of what we're seeing is actually a direct result of that approach. At the state level, as of July 2023, state lawmakers have introduced 165 so-called anti-ESG bills in some 40 states, and at least 14 states have enacted these so-called anti-ESG bills, penalizing companies or investment products or companies involved in investment because of their focus on ESG. We know that states' attorneys generals have collaborated in ways to undermine corporations' efforts around ESG and really make corporations think twice about their continued approach with regard to ESG. In the shareholder realm, we're seeing an uptick in shareholder proposals targeting companies' ESG efforts. We're seeing last year, for the first time, a drop in the average shareholder support for shareholder proposals related to ESG. We're seeing shareholders using litigation to dismantle ESG practices with new threats around antitrust violations, fiduciary duty violations, and the like. At the corporate and institutional level, we're seeing companies pull back from using the term ESG, pull back from engaging in partnerships related to ESG, particularly around the climate sector, and quite frankly, roll back some of their policies and practices. And I'm seeing that real time. I can tell you, even at some law firms, we're seeing a kind of hesitancy around ESG. We saw a lot of ESG practices spring up, and some companies are now pulling back even on their decision of whether or not to start an ESG practice. So ESG is in the crosshairs. lots of people predicting its demise. And so that is certainly what we know around ESG. What do we think we know? Or what do we think? And here I want to talk about 4 things related to what we think and why probably what we think is not true. The 4 things are around: what does ESG even mean? What is its relationship to fiduciary duty? What is its relationship to economic issues? And what does it really look like when we think about corporate governance? So first, what does it really mean? Unfortunately, there's actually a lot of confusion about what ESG actually really is. And a lot of the reason why there's been such intense pushback around ESG is because people are talking across one another. They think they know what it is, and they don't really know. Because in my view, what ESG is not, is that it's not some rebranded version of corporate social responsibility, or CSR. To be sure, advocates of CSR gravitate towards ESG because ESG seeks to ensure that businesses consider important social goals. However, to the extent CSR focuses on these social and climate goals, if you will, without regard to profit, just in order to quote unquote do the right thing, that is decidedly not ESG. And in fact, in 2004, when the ESG term was coined, those who coined that term intentionally shunned the phrase corporate social responsibility and CSR because they didn't want confusion to be developed around the relationship between ESG and CSR. Obviously, that didn't work. And so we have the situation that we think we know that that's what it is, and that's problematic. Lots of people think ESG is stakeholderism. That makes sense. ESG focuses on a variety of different stakeholders, but it's not to be confused with this idea that corporate attention should focus on all stakeholders without regard to prioritizing one or the other, and certainly without regard to shareholders. That is not ESG. Some people actually think ESG is akin to sustainable financing, and this idea, right, that you have to engage in financing that has a quote unquote social impact. Although it is true that you can use ESG factors to have a social impact, sustainable financing is not the same as ESG. And this basic confusion around what we think is driving, right, a lot of some of this blowback. What is ESG? Unlike stakeholderism, ESG is actually explicitly linked to shareholders, and unlike CSR, and it is unlike CSR in that way. Especially because ESG is explicitly linked to financial matters and issues that are financially material. And again, those who coined the phrase were pretty intentional and pretty upfront about this connection. ESG is aimed at acknowledging the fact that environmental and social issues impact a company's economic interests. And the coalition that came together when we were first thinking about ESG was a coalition intentionally of market participants and participants in the financial sector. So ESG is absolutely related to financial materiality. Most importantly, right, the fact that it's related to financial and economic factors has an impact for people on both sides of the spectrum, right? Those who think that it's supposed to be solely about social issues are wringing their hands because they don't like the link with the economics. Of course, and those who think that it's only supposed to be about economics because they don't seem to understand that you can't think about economic issues without actually worrying about the issues that impact our economy are also wringing their hands. And so it's a lot about what we think we know ESG means, even to, and I didn't start off by doing this, defining what is E and S and G. I've gone into certain circles and people think the G is like government or governance, or it is governance, right? Environmental, social governance. People don't understand why those things are together. I'll talk a little bit more about that later, but sometimes people don't even know what the acronym stands for, and that is getting in the way. The second, what do we think we know about how ESG is connected to fiduciary duty? A lot of, at least in the public sphere, is this idea that we think that it's not connected to fiduciary duty, right? ESG has no relationship to companies' pursuit of their fiduciary obligations, and instead is associated somehow with some social or political agenda. And one of the aha factors that you'll see people use over and over again is, wow, you know, there's no proof that this ESG thing has some connection. And more importantly, we found all this negative evidence suggesting, right, that it actually has these negative impacts. The aha moment is just, right, underscoring that they think they know something that is not true. ESG, appropriately embraced, is unequivocally aligned with fiduciary duty. The focus on ESG is rooted in a belief that these issues have an impact on the financial bottom line of a corporation. That aligns with fiduciary duty. Importantly, it is fiduciary duty 101 that corporate officers and directors comply with their fiduciary duty so long as they have a good faith belief that their actions are in the best interest of the shareholders and the corporation. And that's the narrowest definition of what it means to comply with your fiduciary duty. But most importantly, what it definitely does not mean is that you have to have proof, right? So those running around insisting that there is no proof or you need proof, they don't understand fiduciary duty law. It also doesn't matter if it turns out that officers and directors are wrong. Directors and officers make mistakes. The whole point, actually, of fiduciary duty and something called the business judgment rule is that we rely and depend upon boards and directors and officers' ability to use their own business judgment. And we don't try to second guess it. And more importantly, we not only allow for mistakes, but we expect mistakes. The business world expects that there will be mistakes because you're just doing something that you think will work, right? And we're okay with your taking risk. Of course, everywhere except when we think that there is some social or economic implication, then all of a sudden risk goes out the door when you're complying with your fiduciary duty, which is absolutely not true. Perhaps more importantly than that, when we think about fiduciary duty, we're seeing a drumbeat of Delaware cases talking about oversight and the importance of boards' compliance with their oversight duties by focusing on mission-critical issues. And some of those mission-critical issues are social issues. We don't know exactly the parameters of what that means, but we do know that there is some obligation on the part of the board to pay attention to social issues, and as a result, absolutely aligned with fiduciary duty. So that's the first thing. Fiduciary duty is about, do you or do you not have a reasonable belief? And then that begs the question, do we think people have a reasonable belief, or is this just crazy rhetoric, right? The problem is lots of people think it's just crazy rhetoric. And on the one hand, surveys don't support that. Surveys consistently show that a majority of investors, a majority of executives believe that ESG has an impact on long-term financial performance, believe that considering ESG factors is helpful in understanding a company's risk profile and the ultimate financial valuation. 90% of investment managers believe that integrating ESG factors into their investment strategy will improve returns or at least allow them to better assess risk, right? A vast majority of shareholders in a government study indicate that they believe that ESG factors have a substantial impact on a company's financial performance. And we know that the largest institutional investors, the so-called big three, have insisted that their focus on ESG is about economics. Vanguard has said their stance is not an ideological one, but an economic imperative, right? BlackRock has said they focus on sustainability, not because they're environmentalists, but because they're capitalists and fiduciaries to their clients. State Street has also said this is about value and not values. And so much of what we're thinking about with regard to fiduciary duty and what the actors believe they are doing, right, is inconsistent with what we know about fiduciary duty. And more importantly, people say, right, that there's really no reason for that belief. And even that, I think the evidence shows to the contrary, right? There are certainly studies showing that there is a financial connection between ESG and ESG factors, and you know, a company, especially with regard to thinking about downside and risk protection. 60% of institutional investors report that ESG investing has resulted in higher performance. A meta-analysis of kind of 5 years of reports around ESG shows that 58% of these ESG reports reveal a positive link between ESG and investment performance, and close to 10% show a negative link. And the thing to remember is negative or positive is a link, is a connection that you have to take into account. And quite frankly, it's just common sense. We should not throw our common sense out the door when we're thinking about ESG. A 2022 Federal Reserve working paper indicates that the frequency and severity of climate-related disasters is expected to steadily rise over the next decade. Those disasters represent billions of dollars in damages, significant economic implications on employment patterns, capital assets, insurance premiums and insurance coverage, profits, and overall economic activity. There are also opportunities, right, with regard to those weather-related events if a company is innovative enough to think about them. So right now, right, we should have an appreciation for the fact that the belief around economics and climate, and I could use other examples, is substantiated. The other thing that's really important to keep in mind is I keep calling them so-called anti-ESG bills. And you may be wondering why I keep deliberately doing that. I am deliberately doing it because, right, we think that the bills are anti-ESG. But the truth of the matter is that the bills seem to be quintessentially about ESG, especially if you think that ESG is about just driving home some political and social agenda, because many of these bills are not rooted in any zero economic analysis or study, right? Many of these bills are actually, right, persist in the face of evidence suggesting that they have negative economic repercussions for the communities in the industries that they are focused on. And in fact, it feels like these bills are exactly about ideology. So I actually will say they're anti-ESG because ESG is supposed to be thinking about and helping us think about these considerations and their economic implications. And this seems to be doing the exact opposite of that. It also seems to be doing the exact opposite of allowing officers and directors to carry out their fiduciary duty by taking away their discretion around matters that they believe to be important for them to exercise those duties. What else do we think? I think we think that ESG is about some fringe movement involving, right, whatever, however you want to, progressive, left-wing politics. But I think more importantly, involving just a small number of companies that, you know, we can easily target and get rid of this whole ESG phenomena. The reality is, on the ground, ESG has become a pervasive practice within the largest corporations in America. ESG has become entrenched in the corporate governance landscape. ESG disclosure is near universal at these companies. 96% of S&P 500 companies publish voluntary ESG reports. 98% of S&P 500 companies have some form of ESG disclosure in their mandatory filings, most of it focusing on climate, but also on other issues. 90% of S&P companies have made some specific ESG commitment, a lot of it focused around climate. More than 90% of companies have some type of ESG information on their website. 97% of S&P 500 companies have some form of board oversight of ESG, and there's an increasing number of companies that have board oversight lodged in multiple committees or at the full board level. That multiplicity of committees shows the depth and breadth of ESG as a corporate governance enterprise. All of the actors in the corporate ecosystem have focused in on ESG. 91% of business leaders believe they have a responsibility to do so. 90% of institutional investors believe that they need to focus on ESG factors. And then 86% of employees say they would prefer to work for an employer that's concerned about ESG issues, with more than 90% of younger employers indicating the same. Moreover, we're seeing this trend with customers, consumers, and so-called millennials. But here's the thing, right? Even with, because people say it's just about a trend with millennials, nearly half of all investors express an interest in ESG investment products, right? It is a multiple trillion-dollar industry, right? So this is not just something on the fringes. This is something deeply rooted and deeply embedded in our corporate governance landscape. So in short, what we think we know is very inconsistent with what is happening, and right with an appropriate understanding of what ESG is, what fiduciary duty is, what the economic connections to ESG is, and how many companies out there, right, have at least expressed, right, some commitment to ESG. So what comes next? I got my crystal ball out. I'm ready. I am, but don't hold me to it. And, hard to say what comes next in this environment. But I set up that backdrop to let you know that to the extent, right, that we are expecting some easy effort to roll back ESG, right, that is a little bit of an uphill battle given where we are, right, and how different that is from what we think. But what comes next is we got to grapple with the backlash. What are companies doing? Some people, the recommended approach, just be silent, right? So not lots of companies saying, right, we're not going to be too public about our commitment, but right, don't worry, right? We believe these commitments are important to our long-term health and sustainability. So we're going to kind of keep doing what we're doing. We're just not going to talk about it that much. Of course, the danger there is, right, disclosure 101. Our securities laws are premised on this idea that if you don't get good disclosure, right, then it's going to be hard to hold companies accountable, right? We don't let companies go silent about their financial commitments. To the extent ESG is linked to their financial commitments, this feels like, right, what's going to come next is spotty compliance and our inability to kind of figure out what's really going on. And that is, of course, coupled with the fact that lots of companies don't know what they mean when they say ESG, right? And so we're not sure what it means when they say we're going to go silent, but keep it moving. Another way that people are dealing with the backlash is like, we're not going to call it ESG. All right, we're going to change the name, but not the game, is the way I tell my students. I'm not sure, again, what that means. Because remember, we did not even know that people know what ESG means. Now they're going to call it something else, and we don't know what that something else is or how it's going to work. And then we have to keep in mind that grappling with the backlash is not about a cute name change. It's also not about going silent, right? Those who have targeted ESG have essentially said, right, we are going to go away when you stop engaging in the activities, right? And keep in mind, I already said, there's all this disclosure, right? There's a legacy of public-facing commitments, disclosure, et cetera. And so until you pull back on that, you will not be able to decrease the extent to which you may become a target. So I don't know, right, about whether or not the prevailing strategies are going to work. What I do think has to come next is some real thoughtfulness, more than is happening maybe right now, around how do we really deal with the backlash. Next is disclosure, right? What's going to happen with disclosure? Lots of us are like, we thought what was going to happen is the SEC was going to give us mandated climate disclosure. And by now it's been delayed and then delayed. Everybody said October and here we are, right? I don't know. I suppose some type of mandated disclosure will come, but I will say it may end up not mattering. Why? Because where there's silence, the gaps will be filled in, right? There are things happening in the global community around mandated climate disclosure in particular that are impacting companies in the US. These companies operate globally. Their reach and activities does not end at our borders. And so there's likely going to be some continued disclosure for that alone. But if you were paying attention into the climate landscape, what's happening? States are filling in the void. California is going to do what they do. And so California, right, has just passed a mandated disclosure rule that impacts companies doing business in California, thousands of companies. They've done this before around board diversity, and they know we can do it. It'll get challenged. And that may be 2 years worth, right, of disclosure and activity around climate and other forces. And the California law goes so much farther than the SEC's proposal in so many different ways. So that there is going to be some form of mandated disclosure. The other reason why there's going to be some form of mandated disclosure, remember the statistic I told you, lots of companies are already disclosing in their required filing. That's because we already have principle-based human capital disclosure, right? And we already have materiality requirements. The disclosure that's existing now in required filings suggests that companies think that this information is material, that they come up with that conclusion on their own, right? It's hard to imagine they can now all of a sudden go silent around that disclosure. And in fact, in my decades of looking at corporate disclosure, it never goes backwards, it always goes forwards. There's always more as opposed to less. And then finally, of course, there's so much voluntary disclosure out there. And that disclosure, again, hard to imagine it's going to go backwards. And even if companies stop right now with their disclosure, it's out there on their websites, right, in the public domain. Disclosure, I believe, will persist. What about the corporate and board focus? On the one hand, right, I've written a paper that talks about the fact that, boards have already, right, embedded in their committee charters oversight of ESG issues, and the number one ESG issue around which there's oversight is climate and environmental issues. Right? There's already kind of this deeply entrenched, if you will, corporate governance apparatus, which means that you're going to get reports up to the board, which means that you're going to get the board asking questions, right, and trying to do something around accountability because they're going to recognize it as embedded in their fiduciary responsibility, which means that there will be ongoing monitoring, at least at some level. Having said that, how serious and how deeply entrenched the monitoring goes is an open question. We do know that there are lots of skeptics out there. 73% of consumers and employees feel let down by companies' ESG promises. 72% of executives believe that corporations routinely engage in so-called greenwashing, right, where they're pretending to engage in climate-related ESG activities, but that pretense seems inconsistent with their actual practices. And there's been a rise in SEC and shareholder actions targeting companies whose ESG actions do not appear to be consistent with their ESG disclosure, right? So how deep and firmly entrenched these corporate governance practices will be is anyone's guess. I hope that what comes next is actually focusing in on the G. Lots of people, when they think about E, S, and G, first of all, they say, why are we mushing all those things together? One of the reasons why we mush all those things together is because, right, we're trying to say that financial practices sweep broadly across, right, a lot of other issues in our market and in our economy. And in fact overlap. And it's time for us to break down those silos if we really want a holistic understanding of what the long-term health and sustainability of our company looks like. However, there are lots of people that say, but I don't understand this G thing. Right? Like, what's that got to do with anything? The G is absolutely imperative. Interestingly, those who coined the phrase ESG started out by saying, we got to call it GES, but that didn't sound as good. But it's really that G is an anchor to everything else, because the G is about governance. It's about making sure that there are policies and practices that are aimed at ensuring that companies live up to their E and S commitments. So maybe what potentially could come next is that we get serious about the G. And how do we do that? Continued disclosure, in-depth understanding of what ESG means for a given business, a given industry. Oftentimes I'll find that I'll talk to companies, I'll talk to boards, right? And we'll be talking about their concerns with regard to workers, in particular, their concerns about kind of insurance premiums as it relates to climate, all that. And then I'll say, well, let's talk about ESG. And they're like, I don't feel like talking about that. That has nothing to do with us. It's like, we were just talking about, right? And that is a better understanding, right, of materiality and what ESG really means is going to be important. We need best practices around trade-off. Lots of people feel like ESG doesn't work because it's about, it's this big tent. That's what some people refer it to, covering a range of sometimes unrelated activities. And that's too hard to do. So even if companies, right, believe it's important, have a genuine desire to do it, it's just too difficult, right, to try to make these trade-offs. On the one hand, that is an inherent weakness of ESG, right? And people, lots of people, we shouldn't be bringing those letters together. However, I think the weakness has been oversold, right? The fact that different companies do different things and maybe focus on different ESG issues doesn't mean that they can't appropriately commit to moving forward with regarding to address those issues. In the S&P 500 company, we have a hodgepodge of companies ranging from utilities companies to consumer products companies. No one, hopefully no one in their right mind, would suggest that we cannot hold those companies responsible for their financial performance because they look so different. And because, right, the thing that drive their financial performances may be different. So the trade-off thing, I think is an inevitable byproduct of the fact that businesses are different. Businesses look different. Businesses engage with these issues in a different way. It's also the case that this trade-off thing is an inevitable byproduct of business. Right. Companies, in fact, are making these trade-offs every day. This idea that we can't shine a light on how those trade-offs are being made is really not fair, I think. And so I believe what should happen next is, right, let's think about best practices with regard to those trade-offs. Let's think about at the board level, at the committee level, how we are, right, making those trade-offs and what trade-offs will work as we drive towards our long-term health and sustainability. We need training and expertise for the G to work. 97% of directors say they are engaging in ESG oversight. 75% of directors say they are not prepared to oversee ESG disclosures. I don't know what that means, but that should be concerning to everybody as we work through how is this going to work. We also need ongoing monitoring. That's a huge part of the G, and it's the part of the G that we're really unmasking right now. Everybody was all on board. I'm getting net zero tomorrow. I'm giving net zero in 10 years, net zero in 30 years, net right. And then it's like, okay, how are you going to do that? And it's like, oh, wait, we have to come up with a plan. Right? We have to be purposeful. Yes, right. 97% again of boards say they have oversight over ESG. 35% say they do not understand the company's internal controls as it relates to ESG. They do not understand, right, the numbers and figures and information they need to drive towards their goals and their targets. What is that about? Right? That is about the fact that we need better ongoing monitoring. We need processes in place to ensure that boards, that companies are getting the information to make sure that we're doing what we say we are doing. And that doesn't mean that there won't be hiccups or mistakes, but it does mean that we can't understand or shine a light on those hiccups and mistakes if we don't have ongoing monitoring around what needs to happen in this space. So thinking about what comes next, I think is a challenge and an opportunity, right? The challenge is, right, there's all of this backlash. And many people think they know what ESG is, and they don't really know or understand it or fully appreciate it. And many people think that the best thing to do now is to be silent, go dark, right? And yet we kind of have all of these ESG commitments, disclosures, goals in the public marketplace. And we have all of these people saying these things are important for our long-term health and sustainability. That is the opportunity, right? And how we make use of that opportunity is anyone's guess. But I believe, right, that to the extent, even if it's only a small part of our population who really gets it and who really believes, right, that is the opportunity to really drive change around what we really need to happen in this space. That is that companies take seriously the idea that you cannot have a sustainable company, right, whose long-term health and viability will last longer than the next major climate disaster, without really thinking about these issues, how to prepare for them, right? How to overcome them, how to mitigate their risk and fallout. And when people really get that, all right, we are talking about companies in the S&P 500 companies that are the most innovative in the world. And when we get people to understand that, we will get the innovation we need to try to tackle, right, these problems that are really important, not just, of course, to the corporation, but to our market and to our, right, overall country. And so hopefully what comes next is that realization. And with that, I'll stop. And for questions or comments, I could go on, but.
Thank you so much, Professor Fairfax. If you have questions, please pop them in the chat. This is the right time. We have a good amount of time left for questions. I want to thank you. That was really fascinating and kind of squares up with a lot of the things that I've thought about some ESG pledges over the years that we're kind of pledging first and then trying to figure out how to put those pledges into place later, which is a little alarming, some of those statistics you shared. And I know this may not be the most traditional environmental law topic, but given where we are with our climate crisis and the inability to address that in some of our typical command and control environmental legal frameworks that we're used to, these corporate pledges, they really have taken on a very more prominent and much more significant place in this whole system. And so everyone is looking at these pledges and is hopeful that they will achieve the things they're setting out to achieve. So this is a really important topic. Okay,
yeah, and I would say, to that point about greenwashing, everyone is looking at these pledges. Well, not everyone, but many look at them with a skeptical eye. Thinking that some of this is defensive, right? We'll make the pledge, we'll say we're doing the commitment, that will stave off pressure from stakeholders, and it will stave off regulation. Right. And so, there are many people not happy with the state of the pledges and even the fact of the pledges and their voluntary nature. And what I will say with respect to that is I feel like there's no either or. And these pledges are helpful. I don't think that actually people say all the time that it's going to stave off regulation without any proof. And in fact, we're seeing the regulatory wheels moving as we're seeing these pledges. So I don't think it's the case that it's one without the other. The other thing is, we talk about greenwashing, right, or hypocrisy, if you will, without fully realizing what you've said, Sarah, which is a lot of times it's because people actually haven't really thought deeply about how to get there. I don't know that that's the same as being intentionally misleading or trying to, it's like they haven't really thought about it. And, we have to help them to think about it and develop the best practices and not be so quick to say you're not serious. Because some of them, number one, are serious. They just don't, none of us really know. What does it mean to get there in the context of your company? And quite frankly, even if they're not serious, they said it. So now we could do something with that as we think about driving towards change.
All right, well, we've got some good questions here. Jamie asks, do you have any suggestions or ideas for how monitoring of climate commitments or ESG commitments could be implemented? And also, where can we find some of the statistics that you cited today?
Great. A lot of there's a government accountability study. And so many of my statistics were coming from that. There's a PricewaterhouseCoopers study, and many of my statistics came from that study. And I'm trying to, I'll flip through. I wasn't footnoting, but a lot of my statistics came out of those two studies. In terms of just the numbers and the percentages. And I'm sorry, monitoring. I think there are many different ways to monitor. I think disclosure is a monitoring vehicle. That's why we have to keep at it. And if we don't get mandated, we need to press for voluntary. And then after we get the voluntary, we got to get better voluntary. So thinking about how do we close the gap in making sure that the voluntary disclosure is comparable and is accurate, right? And is material and useful is important to that monitoring function. We get monitoring, of course, through the SEC. Even if we don't get the mandates, we get litigation, and that's a useful monitoring device. And then, right, is the corporate governance function is a monitoring function. So that board oversight is a monitoring function. That's what they're doing. They're helping with that accountability. So especially if we're lawyers, but even practitioners, we're thinking about how do we make sure that that monitoring function is real at the corporate governance level, right? That they are taking that function seriously, that they're asking the right questions, getting the right reports and information, right? That statistic about not understanding the internal controls, that's a monitoring problem. And absolutely right, Jamie. One of the things that happens too often is that companies program and look away, commit and look away. And we got to make sure that doesn't happen. Monitoring also can happen through the shareholder proposal process. And there's lots of good things happening there, but also some troubling things aimed at trying to decrease the extent to which climate issues, social issues can be brought up in that sphere. And so making sure that remains a viable avenue is another important piece of the monitoring puzzle.
One follow-up question on monitoring while we're talking about that. Does any state currently have a mandatory monitoring system in place? And do you know when the monitoring in California is going to start?
When you say mandatory monitoring, I guess the answer to that is no. Although New York has these city laws, interestingly enough, that focus on kind of climate issues and disclosure, that is interesting, might a role model that could happen at the city level. The California, I was just looking at it. I believe it's scheduled to be enacted in 2026. So obviously there is some wiggle room around when it's what we are going to get in that area. And I would say disclosure, the Fifth Circuit just upheld the NASDAQ's rule around board diversity disclosure. The reason why that's important is because the whole disclosure regime has been under attack, and that suggests that disclosure continues to be hopefully an important and maybe one of the most important from a legal standpoint ways in which we can engage in monitoring.
Is there any research yet that reveals if the existing disclosure obligations, like the board diversity, are actually improving things? Like in that case, are boards more diverse 2 years after that law?
Oh yeah, absolutely. And I will say the biggest amount of research, and I know you're going to say to cite, but yeah, I think you can go, you can Google kind of California diversity results or something. In the 2 years where California's board diversity rule was in effect, the amount of diversity, and this is just on the gender because that had the longest runway, the amount of diversity in those companies that were governed by that rule, the uptick was astonishing. Like in the kind of triple digits in those companies, and then the next closest state was really in the double digits, and there weren't that many of them before you quickly got into the single digits. Now that's the NASDAQ rule is too new and got challenged, but that is the greatest evidence to date that these disclosure rules work and have a huge impact on company performance. Of course, putting someone on a board is a relatively straightforward, visible thing to do. Determining whether or not a company is continuing to uphold their climate pledge is much more complicated because we got to figure out what that means, what types of activities they have to engage in, et cetera, in order to, to really ensure that we're having a quote unquote impact.
All right, we've got a question here about the New York City retirement case. So, if you believe that ESG considerations are fundamentally incorporated in an adherence to fiduciary duty, does that mean you believe that the New York City retirement case should be dismissed? The case relating to pension plans incorporating ESG concerns in their decision to divest the portfolio. Do you have any ideas generally on that case that you can share?
I think I haven't reviewed the ins and outs, but you've already heard from me that I absolutely believe that the consideration of ESG factors are consistent with the fiduciary obligations of companies and certainly of these investment entities, including New York City and the other major pension funds, right? To think that they can't consider climate-related risk when they're thinking about where to invest and how to invest, just, I don't know that passes the smell test. So from that perspective, yes, I think it should be dismissed because it's based on a fundamental failure to appreciate what ESG is and the importance of using those factors as a tool to understand kind of risk and opportunities as they relate to different investment goals.
Can you speak to the current state of ESG reporting in relation to corporate SEC financial annual reporting, in particular, the degree of rigor that is or is not applied to ESG disclosures and robustness of associated audit programs, and especially for ESG annual reports that are released separately from SEC type annual report? Where are the most S&P 500 entities along this continuum?
Yeah, so I'll take that question to mean that, of course, there is a distinction between these voluntary freestanding ESG reports, right? And then the ESG information that is being reported in these required filings, right? So I said 98% of S&P 500 companies have some form of ESG disclosure in their mandatory filings, that is, in their proxy statements or their 10Ks, right? And then I said 96% of S&P 500 companies publish voluntary ESG reporting. And yes, we should understand that those are two distinct things and two different things. And absolutely, that question highlights the fact that there is concern about the relative rigor with regard to kind of those two sets of information. Right. One of the reasons why people want mandated disclosure, notwithstanding the fact that we got all this voluntary disclosure, is because they believe that when you have disclosure coming through these annual reports, it's going to be subject to more rigor. There's already a process in place, right? An audit committee that's exercising control about the information that's coming through and how they're reporting and what they're reporting, et cetera. So it's my belief that there is more rigor in that process, more rigor in that information. One of the things, though, that we're finding is that there is less information in those reports and less detailed information. What do we make of that distinction? Some people say it's just a matter of real estate. There's only so much you can put in the 10K, given that there's all this other stuff there. And so that's why there's this other stuff happening on the voluntary side. Some people say it's a question of materiality. We've got the material stuff here, and then all this other stuff that we think is focused on stakeholders. And other people are concerned that it is about, right, this is the only thing we could kind of check and have quality controls around. And now we got the rest of this. So I do think that at least some research suggests that that voluntary information is not subject to the same rigor, right? And therefore may be less accurate. Less complete, and importantly, not overseen by our traditional internal controls, i.e. the board and auditors and, et cetera, right? And so I think that one thing that needs to happen is that we need the audit function to be focused on these types of things in order to make sure that there's greater rigor. One trend that I think people should be aware of that could help in this situation is the SEC has basically said, look, we're going to look at your voluntary reports and we're going to compare that to your required reports. And then we're going to ask you why is there a difference? right? Why haven't you reported here what you've reported there? And you're going to have to, and I think that has woken up a lot of companies to say, yeah, we've got to do more with regard to rigor on the voluntary side, and ensuring that the numbers not only match up, but that there's greater accuracy with regard to those voluntary numbers.
So Patricia is wondering, how can we get buy-in from CEOs, directors, et cetera, and work on governance if they're one of the skeptics you mentioned?
Well, I mean, one of the ways we can get buy-in is that to remind them that it's too late. Skeptical or not, we're gonna take a look at their website. We're gonna take a look at their voluntary report. We're gonna take a look at their charter. We're gonna take a look at their proxy. And what all of that is going to tell you without a doubt is they've already made the commitment, right? Sarah, it's done. I have done some consulting and you know, I'll ask people, what are you guys doing around ESG? And they'll be like, oh, not really that much. And then I'll like read statements out to them. Oh my gosh, that's crazy. Where's that from your website? Right, your charter, right? Usually not your charter doc, but and so one of the things that you can do to get them on board is to have them understand the risks, the present risks that they already have opened up for themselves, because this disclosure is already a matter of public record. And now we've got to back that up so that that doesn't turn into a nightmare for us. And so I think absolutely. The second thing is to get them to have this conversation. Okay, this is all the stuff you said that you think it means, without calling you a liar. What do you really think it means? And how do you think it relates to the company? And that is also the third thing I think we can do, is to have more training around ESG, how it's connected, what does it mean? Look at the documents and the evidence. You know, boards and officers are busy doing, right? Not stopping to train and to learn, except when there's a crisis. We need to admit them to understand that you're at a crisis because you're at a risk inflection. And if someone realizes these inconsistencies, it's going to be a problem for you. So we need to now step back and think critically about what to do.
So I will point out before we do the last question here that we do have the CLE submission link in the chat. So I know that's important for some folks. So if you need CLE, go ahead and make sure you put that in a separate tab here. Do you think the EU Corporate Sustainability Reporting Directive is a good model?
I will say, while I know the broad brushes of that directive, I would not want to step into doing what I just said CEOs and directors should not do, is to make commitments around it without really appreciating kind of the specifics of it. What I will say is one of the positives around what's happening in the EU is that it is forcing the hands of the American companies. Actually, one of the reasons why we have gotten this demand for SEC action is because those companies are feeling the heat of having to comply with the EU directive. Some of them are working in Canada. Right now, we got California, right, breathing down our necks. And if California does it, it could be others. And so for companies, this desire to have some type of harmonization is really important. And so I think that that is a positive development, you know, for all of us. As we try to think through, I know that in the EU and in Canada and in California, there tend to be many more mandates than the US is used to seeing and used to embracing. And that sits uncomfortably with a lot of people. And yet it is a reality of where the global community is going. And now you see some states are going.
Okay, all right. Looks like we just have a few minutes left here. One question, please provide a couple examples of the trade-offs you spoke about.
Oh, yeah. I mean, the examples are plentiful, right? You know, if you, for example, have to think through, you know, whether and to what extent you should be focused. Well, I'll do one easier example, like whether and to, if you made a commitment to make sure that you're going to focus on kind of climate issues writ large, how does that square with commitments that you may have made about investing or not investing in certain communities? You know, it's also the case that if you've made a commitment with regard to climate, or put it differently, because some companies have made a commitment with regard to the environment, there are a bunch of different issues associated with the environment that come into play, right? Is this about a commitment to recycling, right? A commitment around water rights, or a commitment around something else altogether? Of course, there are also economic trade-offs. We cannot dodge the fact that sometimes, at the very least, there are short-term costs with doing things that we think are protective of the environment. And those are short-term economic costs that could have real-time consequences, right, for your workers, and even the rank and file workers, and how we engage around them. You know, when I think, and I've done a lot more work on the S side, and you think about companies that have made commitments to workers, you know, what does that mean? If you are in the airline industry and you've made a commitment to your workers, it turns out that some workers want some things and other workers want others, right? And what does that mean as you're thinking through, you know, how to actualize that commitment? So I think it's both about trade-offs within given categories. The environmental, it's about trade-offs between the categories, and of course about trade-offs with regard to these objectives and economic ones. And I think one of the mistakes we have made, especially with regard to these objectives and economic ones, is to suggest that there are no trade-offs. Like I said, win-win. That could be true in the long run, but in the short run, right, resources have to be spent, right? Resources have to be allocated towards one thing, and usually that means away from something else. And we've got to decide and make really important decisions. And sometimes those decisions are, right, we've got to put our money towards ensuring that our workers have certain benefits, and that our workers are able to kind of stave off inflation and do all this. And that may mean that we can't do as much as we wanted to do in and around our climate goals. That's what it may mean. Some people may say that's usually fake. You got more than enough money to, right, do it all. But sometimes you don't. And choices have to be made.
All right, well, please join me in thanking Professor Fairfax for this wonderful presentation. We really, really appreciate you giving us your lunch hour today. It was informative, and it's such an important topic. We will have a spring speaker. We will be touching on ESG again. I think there's plenty to talk about. So we'll be talking about it from a different perspective in the spring. So please keep a lookout for that. And thank you, Professor Fairfax. And thank you, McNeese, Wallace, and Newrick for sponsoring today. So have a great day. Thank you, Professor Fairfax.
Thank you. Thank you so much for having me.